Hello, hello, hello. Let's pop out chat. Hello, hello, hello. I know I don't have any notifications left, but if I'm to do this, I've got to do it right away because I've got to go out. I don't see anyone at the moment. I've got someone in there. Is the sound all right? Then I'll get going. Because I do have to go out, but we have a new motion in the Wallace v Vegas. And I know I don't have any notifications left today, but this is just to get it down, because otherwise I won't be able to get it down. So I won't be interacting audio with a slight echo. Okay. Wonder if that's picking that up from my... Is that any better? Maybe I'll talk a bit closer, and there we go. Right. 1 second. Okay, I'm going to keep going unless I see something in the chat. Echo. Why is there an echo? Maybe it's the room I'm in. I don't know. How about now? Is that better? That should be better, hopefully. You can still hear me? Looking in the chat. Looking in the chat. Alex, can you still hear me? Okay, good. Right, let's go. Because I haven't got much time, so I'm just going to run through it. Defendants replied to plaintiff's opposition to motion to stay discovery. Defendants Las Vegas Metropolitan Police Department, Christopher Torres, Jason Shoemaker, and Corey McCormick, by and through their attorney of record, Marcus Urbach, hereby file their reply to plaintiff's opposition to motion to stay discovery. This reply is made and based upon the memorandum of points and authorities, the pleadings and papers on file herein, and any oral argument allowed at the time of the hearing. Memorandum of points and authorities. 1. Introduction. On September 12, 2023, defendants filed their motion to stay discovery. Plaintiff Floyd Wallace opposed the motion the same day. Defendants now reply. 2. Legal argument. Courts in this district have formulated 3 requirements in determining whether to stay discovery pending resolution of a potentially dispositive motion. Motions to stay may be granted when 1. The pending motion is potentially dispositive. 2. The potentially dispositive motion can be decided without additional discovery. And 3. The court has taken a preliminary peek at the merits of the potentially dispositive motion and is convinced that the plaintiff will be unable to state a claim for relief. Citation. Wallace's opposition confirms that all 3 factors weigh in the defendant's favour. A. Potentially dispositive. Both defendants' motions to dismiss request dismissal of all claims. Wallace does not contest this fact. B. Additional discovery is not necessary. Wallace's complaint contains sufficient facts for the court to conclude all of Wallace's claims fail as a matter of law. In addition, Wallace videotaped the entire encounter. He has submitted his videos to the court and requested the court take judicial notice of them. Therefore, no genuine issues of material fact exist as to what occurred, and no additional discovery is necessary to resolve the legal issues in defendants' motions. Wallace does not contest this fact. C. Preliminary peek. The final requirement is for this court to conduct a preliminary peek of the merits of the motions to dismiss to determine the likelihood that the claims will be dismissed. Citation. Wallace argues the defendants admit that they 1. Detained him without reasonable suspicion, 2. Used excessive force, 3. Arrested him without probable cause for exercising his First Amendment rights, and 4. Performed a custodial arrest when they could have just cited him. The defendants do not admit any of these facts, and each argument is easily defeated. Lack of reasonable suspicion. Wallace's complaint and video confirmed that he travelled to an LVMPD substation, put on a mask, and then began to act suspiciously by approaching secured areas and filming. This admitted behaviour certainly justified the officer's decision to detain Wallace. In fact, Wallace did the same thing at a Texas police station, and the Fifth Circuit found his claims untenable as a matter of law. And the citation. Reasonable suspicion existed to detain and probable cause existed to arrest Wallace when he was filming outside a Texas police station and avoiding the police. His own case quoted back at him. Excessive force. Wallace claims his excessive force claim will survive dismissal because his video shows an officer pointed a gun at him. This fact is insufficient to state an excessive force claim. The video shows an officer approaching Wallace when he was on the sidewalk. It is undisputed that Wallace was masked, acting suspicious, ignoring the officer's commands to stop, and he had not been searched. The officer, who is several feet away from Wallace, has his firearm out until Wallace stops and complies. The video shows the officer never pointed the gun at Wallace's head, and he holstered the weapon the moment Wallace complied. According to the Ninth Circuit, the drawing of a weapon becomes unreasonable when a police officer terrorizes a civilian by brandishing a cocked gun in front of that civilian's face while investigating a minor crime against a citizen. Citation. The video confirms that the firearm was never pointed at Wallace's face and that the officer never terrorized Wallace. No reasonable jury could review the video and find that the officer's decision to temporarily draw his firearm until Wallace complied was unreasonable. Also, Wallace does not argue any clearly established law prohibited the officer's use of the firearm under similar circumstances. Therefore, at a minimum, the officer is entitled to qualified immunity. Lack of probable cause to arrest. Wallace argues the officers lacked probable cause to arrest him because they arrested him for exercising his First Amendment rights. Wallace was not arrested for exercising his First Amendment rights. He was arrested for attempted trespass, and probable cause existed for his arrest. Probable cause requires only a probability or substantial chance of criminal activity, not an actual showing of such activity, and is not a high bar. Citation. In Nevada, probable cause can be based on slight evidence. Citation. The officers arrested Wallace for attempted trespass, and that statute makes it a misdemeanor for any person under circumstances not amounting to a burglary to go upon the land or into any building of another with intent to vex or annoy the owner or occupant thereof, or to commit any unlawful act. Here, Wallace's video confirms he went onto the LVMPD property to vex and annoy its occupants and to provoke a police encounter. Undeniably, probable cause existed. Also, the video and complaint established that Wallace refused to identify himself for over 3 minutes after being asked to do so. And there's the statute. It is obstruction under Nevada law to impede and prolong an investigation. Citation. Nevada district courts have held that an individual is obstructing when the individual is given several opportunities to comply with defendant's orders but fails to do so. Citation. Wallace admits, and his video establishes, that he impeded the officer's investigation by failing to identify himself for over 3 minutes after being asked to do so. Case we all know, Hibel. Citation. Principles of Terry permit requiring a suspect to disclose his name during a Terry stop. Therefore, at a minimum, probable cause also existed to arrest Wallace for obstruction. The fact the officers did not arrest Wallace for obstruction is irrelevant. Citation. Because the probable cause standard is objective, probable cause supports an arrest so long as the arresting officers have probable cause to arrest for any criminal offence, regardless of their stated reason for the arrest. Finally, the officers learned Wallace had a warrant from another jurisdiction and could have arrested him on that basis. Thus, the officers had ample probable cause to arrest Wallace. Custodial arrest v citation. Wallace argues an issue exists because the officers performed a custodial arrest when they could have just cited him for a misdemeanor. This argument is irrelevant. The Supreme Court has stated that if an officer has probable cause to believe that an individual has committed even a very minor criminal offence in his presence, he may, without violating the Fourth Amendment, arrest the offender. Citation. Therefore, as a matter of law, the officers did not violate Wallace's constitutional rights by performing a custodial arrest for a minor offence. Conclusion. Based on the above, defendants request that this court grant a stay of discovery until the defendants' motions to dismiss are resolved. Okay, that's dated today, obviously. Is the 19th, yeah. Apologies, chat. I had to go straight live. I'd have probably done a standalone, but I've got to go out. I haven't got any time to chat. Thanks for joining me. I'll catch you later. Cheers.